Thanks for joining us for this webinar with Level Set and Procopio's attorney, Mary Salamone. She's going to present about preservation of construction claims, and I will let Mary introduce herself. And if you have any questions regarding the material or topic, just type them in the chat box or the Q&A panel. Either of those is fine, and we'll be sure to get to your questions, or we can also have some time at the end where we'll answer those questions. So I'll let Mary get started. Thanks.
Thank you, Catherine, and thank you for everyone for participating in today's webinar. As Catherine mentioned, and as you can see on the PowerPoint slide, my name is Mary Salamone, and I'm a partner with the Procopio law firm. Just by way of a very brief self-introduction, I've been practicing exclusively in the area of construction law now for roughly 34 years. I've had the privilege to represent virtually every participant in the construction industry, ranging from owners, both public and private, general contractors, subcontractors, design professionals, construction managers, and material suppliers. So I've seen projects from various vantage points, and that often assists me in trying to find some resolution of a dispute. But far too often over my career, I've encountered situations where clients have neglected to thoroughly review contracts that they have signed to find out that when I'm later retained as counsel and consulted, that they have a problem in their contract documents themselves and their execution of the requirements in those contract documents. So the purpose of today's webinar is to alert you to some of these contractual provisions that potentially cause problems by hampering or restricting in some way your rights of recovery for whether they be schedule delays or for additional work you may have performed on the project. So let's start by reviewing just a quick agenda I had prepared of the topics that we're going to cover in the next 30 minutes. So one of the first things I want to talk about is notice requirements, because this is really a driver for your ability to perfect claim rights. The next subject I want to highlight for you certain contract clauses that have the effect of limiting potential recovery for claims. Third, I want to talk to you about some change order issues and some inadvertent releases you may be giving through the change order process that you are probably not even cognizant of. And then the last thing, I always have to stress the importance of essential record keeping, because without this kind of fundamental information, you're going to have a hard time going into court and proving up your claim. As the claimant, you bear that burden of proof or burden of persuasion with any trier of fact. And so that record keeping is essential. I had a client once that said when he met with his project team, he would refer to this as the rock pile. All these records constituting rocks in the rock pile. And he would tell his people, you always want your rock pile to be bigger than the rock pile of whether it be the owner, the general contractor, depending on what your role is on the project. And so that's how he thought of it and communicated it to people. But it's an often overlooked issue, and it's critical because the old school way of building projects of, I don't want to get involved in this paperwork, just get out of my way, and the crusty old superintendent saying, let me just get this job built. That's not going to work today. That's just not going to fly. So let's jump in and talk about notice requirements to start. I cannot emphasize enough again, you have to read your contract in this regard. And you shouldn't just read the contract with this aspect in mind at the time you're looking at it, hopefully to decide what provisions you want to add or remove. You need to make sure when that handoff is done to whoever's going to run that project for you, that they're reading that contract and they know the timelines they have. I don't think I've ever seen a contract that doesn't have some type of notice requirement in it. and whether it be the general has to provide notice to the owner, the sub has to provide notice to the general through some flow down provision, there's always some type of a notice provision. And many contracts require an initial notification, has to then be followed by supporting schedule analysis. That may be something like what we call a fragnet or a time impact analysis, detailed costs, and supporting documentation. So you want to implement strict compliance guidelines for each project. And that includes not only the timing of the notice given, but adhering to the method of delivery of that notice, because these contracts specify that as well quite often. Now, what are the types of notices that could be given? Well, typically, if you're encountering some type of a differing site condition, you're going to have to give notice. Errors and omissions in the plans and specifications trigger notice requirements. Changed or extra work, and then schedule delays and impacts that you may encounter out there. So I always tell people, you have to make sure you're adhering to this. You cannot assume that the owner, the general contractor, or a court is going to take a relaxed view of notice. While I'm located in California, I've been advised that other jurisdictions on the East Coast take an incredibly stringent view of notice. So basically, that's kind of, if you will, the ticket to enter the theater. Without that notice, a court's not even going to let you file that complaint. California is a little more relaxed about that. California adheres to more what I'll call like a substantial compliance requirement, but the courts are not going to turn and look the other way if there's absolutely no notice given whatsoever. And there's a rationale for giving the notice. The purpose is the owner has the ability to conduct an investigation and to actively participate in a resolution such that they can potentially mitigate damages. So there's a reason for it. It's not just done, to torment you all. That's just one of the rationales for it. Now, to help everybody understand when they look at a contract, what is a notice provision, I've extracted from the AIA A201 2017 edition of the general conditions. And AIA is just the American Institute of Architects. This is a commonly used form contract used nationwide. And under this type of contract, you'll see there's a section titled, it's section 15.1.3, Notice of Claims. And it says claims by either the owner or the contractor, when the condition giving rise to the claim is first discovered, shall be initiated by notice to the other party. Claims by either party under this section shall be initiated within 21 days after the occurrence of the event giving rise to such claim, or within 21 days after the claimant first recognizes the condition giving rise to the claim, whichever is later. So these are the types of notice provisions you have to be very aware of and make sure that your project team is aware of and that they are adhering to them. This, in the backdrop of this next slide, is a contract that I've actually had to work with. Regrettably, I received this contract after it was executed, and there are just some landmines in this agreement, and so I've called out a few of the provisions here with regard to notice because they are incredibly harsh. And this is the type of verbiage you want to be on the alert for when you're reviewing a contract. Under this particular section 8.3, this dealt with requests for extensions of time. The contractor was required within 7 days of the discovery of the circumstances constituting a basis for contract adjustment to submit to the owner a complete or preliminary draft of that change order request. If the preliminary draft is submitted, it shall then be followed within 21 days with a complete request for extension that includes more detailed information. And that's kind of what I referred to in an earlier slide. This is just an example of what that language would look like. So this particular contract had a very short time frame of 7 days. The contract got worse though, because it provided that failure by the contractor to provide a timely and complete request for extension in accordance with that section 8.3 shall constitute a waiver by the contractor of the right to a contract adjustment on account of such circumstances. So this had a very clear waiver provision in the event of noncompliance. It got worse in this agreement. Uh, the contract says, contractor recognizes and acknowledges that timely submission of a complete request for extension is not a mere formality, but is of crucial importance to the ability of the owner to promptly identify, prioritize, evaluate, and mitigate the potential effects of changes. So in other words, the attorney that drafted this is articulating that this is just not a formality. There is a significance to this. So in other words, court or jury, I'm not requesting this just to be difficult and onerous. There's a reason behind it. It goes on to say, though, any forms of informal notice, whether verbal or written, that included things like notations in meeting minutes, daily logs, updated construction narratives or look ahead schedules. Often you'll see narratives accompany those. This contract deemed those notations of impact as not being in compliance with the formal notice requirements of this contract. Those are types of provisions you either want to strike through when you're reviewing these contracts, or you want to make sure that your project team is acutely aware of the fact that there has to be a discrete, separate written notice given either through an email or some kind of a formal letter, and you cannot rely on notifications given through meeting minutes, schedule update narratives, and the like, daily logs. Even if those logs are delivered to the owner, it will not be deemed effective for compliance here. Now, I'm going to just share with you quickly a case here in California, because it really kind of drives home some of these issues about notice and how the courts will tend to treat them. Under this Greg Opinski versus City of Oakdale case, these are just some of the facts of that case. In that particular case, the contract required a written change order for all modifications to price or time. And the contractor was required to submit a request for time extension within 30 days of any triggering event. It went on to say that no time extension would be valid unless it was made in accordance with the contract. Well, the contractor completed the work late under this particular project, and the city assessed liquidated damages. That's what LD stands for. For those of you that may not be familiar with that terminology, just very quickly, liquidated damages are typically a provision in contracts, routinely seen in public works contracts. They may also be in private works contracts, but it provides a daily rate of damages the owner will be damaged by in the event the project is delivered late. So in this particular case, the contractor argued that it was excused from giving any notice because their argument was that the city had caused all the delay on the project. Well, what was the holding of that case? The court basically blessed the fact that the contract could require certain procedures that the parties had to adhere to if they were requesting time extensions. So the court said, that is perfectly acceptable that those procedures could be outlined in the contract. So the court was not willing to negate those, and found that the contractor's failure to give notice of a delay claim in accordance with the requirements of the contract barred any defense based on the city's alleged fault. So basically, the court refused to consider any evidence that the contractor wanted to offer that perhaps timely performance was rendered impossible by the city and through the city's actions or inactions. And the court upheld the assessment of liquidated damages. So this kind of drives home the point of how critical notice can be in these contracts. These are just a few tips for drafting a delay letter. I'm not going to go over all of them. I'm just going to highlight a few, but you want to make sure that you have the proper recipient of any notice. That often is not the person on the job site that you may be dealing with day to day, and you may see reference in the contract that formal notice of any kind of schedule impact or additional compensation request should be directed to, for instance, the Director of Public Works, or the contracting officer, or the officer in charge, words to that effect. You want to provide an introductory sentence or paragraph telling them what you're going to tell them. That's kind of always the rule when you write anything. Tell people what you're going to tell them then, and then summarize what you just got done telling them. You want to highlight, the date you encountered any change condition, any pertinent information. You have to make sure you're drafting these things as if you're explaining them to a third party with no knowledge whatsoever. And you can see I've listed here some of the other requirements, such as making sure you're providing detailed backup of photos, emails, RFI references, things of the like. Next, I'm going to transition now to talking about some contract clauses that limit recovery. And the first one I've put up here is a no damages for delay clause. What are those? Well, this is an example of some of the language that you would see that we would call a no damages for delay clause. It basically says, notwithstanding any other provision of this contract, the contractor will not be entitled to claim any liabilities resulting from any delay or disruption, and a claim for an extension of time will be the contractor's, that should be sole, not sole and exclusive remedy in respect of any delay or disruption. And the contractor will not be entitled to make any other claim. So in other words, the owner can give you a time extension, but that's your sole remedy. And I've seen these provisions in subcontracts as well. So I don't want you to think just because I've shown this particular example that it's exclusive to a contract between an owner and a general. It is not. So this is an incredibly harmful clause if you're on the receiving end of it. If you're an owner, you're going to love it. If you're a general, forcing it on a sub, you're going to love it. But if you're on the receiving end of it, these are types of clauses you want to make sure you strike through. Depending on the nature of the delay and the jurisdiction where the project is located, the contractual prohibition against delay damages may very well be enforceable. There's very limited exceptions. Typically, they have to be things like bad faith, you have to show fraud, gross negligence, active interference, or abandonment of the contract. And what do we mean by abandonment of the contract? Well, basically, both of the parties failed to follow the change order process, and there are significant changes that were being made to the project drawing. So you have to show both of those things. Now, in California, for instance, these types of clauses are not allowed in public works contracts. But as far as private works are concerned, these are fair game. Next, I'm going to move to discussing per diem clauses. What do I mean by that? Well, again, here's an exemplar clause that you may see. It says contractors shall be reimbursed for general conditions and general requirements costs at the sum of $10,000 per day for such compensable delay that occurs over the entirety of the contractor's performance of the work. Now, sometimes in the industry, these have also been referred to as reverse liquidated damages clauses. So under the liquidated damage clause, I explained earlier that an owner will ask a contractor that this is the amount of damages you're going to owe me in the event you delay the project. This says in the event the owner delays the project, what the contractor is going to be entitled to receive. And what you have to make extremely careful of is that you're looking at that contract language very carefully to make sure it's not scooping up, not just your costs as the general contractor, but sometimes this verbiage can include subcontractor costs. And I had a case where the general contractor did not carefully read this verbiage. They were asked to submit a rate, a per diem rate, as part of a formal bidding process. They did not understand that the contract was asking not only for the general contractor's damages in the event of delay, but was also to include the subcontractors. They inadvertently just included enough money to cover their costs. So that's why these types of provisions, you need to carefully review them. And if you're required to provide some kind of a per diem, you have to make sure what the scope of it is. Now, I want to discuss another issue about some potential contract clauses that limit recovery. This is, again, an excerpt from that very draconian contract that I'm dealing with for another client. And I've kind of put this under the header of requirements after claim denial. And under this particular section, which is titled Owner's Decision, it talks about the fact that the owner is going to make a good faith determination within 30 days after the owner receives a completed claim. But it goes on to say that if there is no good faith determination that's issued by the owner within that time period, the claim will be deemed denied. And project staff, I don't believe, understood that they just couldn't wait and wait and wait for the owner to respond, because the owner in this case never responded to anything, because of this verbiage that that claim would therefore be deemed denied. Because then if the claim is deemed denied, it triggered some other obligations to the contractor. In this case, it says if the contractor disputes the good faith determination or deemed denial, then it shall personally deliver to owner a written protest within 30 days. And then it says, if the contractor fails to do so, the good faith determination or deemed denial of the claim will, without further notice, become final and binding upon contractor. So you have to make sure that you are not only reading notice requirements, but you're reading requirements that may be embedded in a claims process that you may see either under headers such as request for time extension or change order administration. This is a clause I took from a completely different project. And in this case, I was representing a subcontractor who had millions of dollars of claims for change orders. And there was verbiage in the contract that attempted to oppose a limitation on change order recovery. And it said payment on account of pending changes made by owner shall be made only if contractor, and here it was referring to the general contractor, receives a change order from the owner for subcontractor's change work. And then contractor's liability to subcontractor shall be limited to the amount of the owner's change order allocable to subcontractor's changed work. In this case, the general contractor was mounting a defense that we never received a change order from the owner for this. It was unclear to the subcontractor why that occurred. Frankly, it could have been as a result of actions or inactions by the general contractor, failure to give notice by the general contractor, failure to meet deadlines that the contract imposed on the general contractor. But for those subcontractors listening to today's webinar, this is the type of language you're probably going to want to strike through, because if you're in a jurisdiction where this is enforced, you're at the mercy of the general contractor, who may not have necessarily adhered to the contract and protected your interests accordingly. And under some verbiage like this, you would potentially bear the burden of that. Now let's move to another contract clause. This one falls under the nomenclature of waiver of consequential damages. Well, probably many of you have had this in your contracts. You may have not necessarily understood entirely what it is. It's very common in contracts to see what we call a mutual waiver of consequential damages. And consequential damages are typically damages that flow from some type of a breach that are not, added general conditions cost or lost labor productivity, things of that nature. In this case, it defined those consequential damages for the contractor as damages incurred by the contractor for the principal office expenses, including the compensation of personnel stationed there, for home office overhead, for impairment of bonding capacity, for losses of financing, business and reputation, and for loss of profit. So if there's some breach that you feel has caused you to be on that project longer, this provision says we're not going to compensate you for personnel that may be stationed at the home office, for those overheads, for the fact that you couldn't go out and bid on other projects, things of that nature. They would fall under the just description of consequential damages, and you would not be able to seek recovery for that. Moving to change orders. I want to start with just a few words of caution. I have many, but I had limited time. So these are more of the highlights. You always want to avoid taking verbal orders to perform extra work. These typically are not going to be binding on public agencies. So whether you're a general or whether you're a subcontractor, you really don't want to be taking verbal orders from anybody to perform extra work. You want to get that in writing. If you are directed to perform extra work, you should be tracking labor and material costs on a daily basis. And you're going to want, if you're dealing with the owner and you're the general, you're going to want the owner to sign off on tickets. If you're a sub, you're going to want the general to sign off on your tickets. If the parties can't agree that it is actually at its scope, at least get a sign off verifying the crew size out there, the equipment, the hours worked. That then minimizes the debate that may ensue later on. Once you get maybe a ruling on the entitlement, then at least the quantification is there and it's not hopefully debatable. And you don't want to have people out there on your site just randomly signing anything that's put in front of them. I was representing a general contractor. He had a superintendent out there that basically signed whatever was put in front of him. And as a result of that, there was an allegation that we were bound to pay those tickets. He later then had me amend his contract wisely to state only the project manager had the ability to sign up on tickets, and any signature from any individual on the site under that designation would not be binding. And you do not want to be signing change orders with 0 days filled in if you feel that you have a time impact. That's when the acronym TBD is critical, to be determined. Now, I'm going to show you a sample change order because sometimes in the language, and you'll see there's this very fine print at the bottom of this change order. As an attorney, my eyes instantly focus on the small print. A layperson doesn't focus on the small print like I would. And in that small print is embedded some very dangerous language that you would probably not recognize as such in reading it. I've highlighted it in red print, and I'm going to explain to you why that language has such significance in the legal world. It says, by signing this change order, the contractor acknowledges and agrees that the stipulated compensation includes payment for all work contained in the change order, plus all payment for the interruption of schedules, extended overhead costs, delay, and all impact, ripple effect, or cumulative impact on all other work under the contract. What that means is if you have a project where you have dozens of changes, and they may be rather small in and of themselves, but when you aggregate them, you get to what we call the death by 1,000 cuts. And now you're hemorrhaging on this project because everywhere you turn, there's a change. Signing change orders that have that verbiage on it release that claim. We had a client that did this. They didn't understand the language. Of course, the ownership argued, oh no, you signed these that released these claims. You have to be mindful. These words have impact. And they may not only be in your change orders, as I noted here in the box to the left, you got to review your contract because your contract may have a provision in it that states that as well. I did want to talk about essential record keeping. That's a subject I can't give a webinar without at least talking to some degree. You have to make sure you're keeping certain documents to bear your burden of proof. For starters, that would mean an estimate and all your bid documents, your takeoff worksheets, any management cuts, etc. I represented a very large international contractor once. They lost their bid on a contract. Well, when you lose your bid, it becomes a real problem for me trying to prove up your damages in terms of demonstrating what you thought at the time you bid the project about, production rates, etc. Another very key document, daily progress reports, and these have to be filled out in detail. In California, what I tell clients is, don't tell me it's sunny and 75, it's that every day. You need to give more meaningful detail. Photographs and videos, that goes to the old adage of a picture speaks 1,000 words. It's true. Meeting minutes, maintaining your baseline schedule and monthly updates, and critical is your detailed job cost report, because from that is what we measure what the harm was. So I always tell you, you have to remember that written documents are given more weight by a trier of fact than any person's memory is going to. If it wasn't written, it wasn't said. A trier of fact is going to rely more heavily on what the documents are saying than what people are testifying based on memory occurred, often 3 years ago from when they're taking the stand or sitting in a deposition. So at this point, we're right at 11:30. I'm happy to address any questions if we can, and unless our time is up, Catherine, I would defer to you on that.
That was perfect timing, Mary. Great presentation. Thank you so much. And I do have a question while we wait to see if anyone else does about which of the provisions you've talked about affect the right to file a mechanic's lien, or do any of them?
Um, I would tell you, mechanics liens are a very statutory intensive animal that are somewhat outside the scope of this presentation. Um, I would tell you to be mindful of what jurisdiction you're in terms of what you're going to put in your mechanics lien. For instance, in the state of California, if you are found to have willfully overstated the amount of that lien, the court will render that lien null and void. Now, I think a court or a trier of fact may be hard pressed to find that you put in amounts that you believe you've adequately satisfied the notice requirements for is constituting willful overstatement. But there are a whole slew of other statutory requirements California you would have to adhere to in order to enforce mechanics lien.
Thank you. Great answer. Anyone out there, don't be shy. Please ask your questions about anything that Mary covered here. And if you have other questions about construction payment, lien rights management, anything related to getting paid as a contractor, you can go to levelset.com, and just at the top there it says ask a question, and you just go right there, and we have a whole community of construction attorneys across the country.
And I've also included in this last slide my email information. Anyone on the call, you can feel free to reach out to me. If you're too bashful to ask a question during the webinar or something else has cropped up since the webinar, feel free to send me an email and ask me a question.
Thanks, everyone. Have a great day. Thank you again, Mary.